সকলকে আবারও আমন্ত্রণ ক্রিমিনাল জাস্টিস প্রোগ্রাম দেখবার জন্য। আমি সলিসিটর শাফিউল আজম, প্রিন্সিপাল অফ আজাম এন্ড কো সলিসিটার্স, এবং আমার সাথে আছেন ক্রিমিনাল লয়ের স্পেশালিস্ট ব্যারিস্টার আমার কলিগ ব্যারিস্টার ফয়সাল সাইফি। ফার্স্ট সেগমেন্টে আমি বলছিলাম অ্যাকাউন্ট ফ্রিজিং অর্ডার, যেটা পুলিশ এবং আপনার বিভিন্ন ইনভেস্টিগেটিং অথরিটি তারা এখন কোর্ট থেকে আপনার অর্ডার বের করতে পারে। রিজনেবল গ্রাউন্ডস ফর ফ্রিজিং, একটা রিজনেবল গ্রাউন্ডস থাকতে হবে ব্যাংকের অ্যাকাউন্ট যদি ফ্রিজ করতে হয়। ইট ইজ নট জাস্ট ক্যাশ দ্যাট ক্যান বি দ্য সাবজেক্ট অফ সামারি সিজার। মানি ইন দ্য ব্যাংক ক্যান নাও অলসো বি সিজড। আগে আপনারা শুনছেন ক্যাশ সিজার, এয়ারপোর্টে ধরলে মানি সিজ করছে 1000 পাউন্ডের উপরে হইলে, রাস্তায় ধরলে বা কাজের জায়গায় তারা যদি সাসপেক্ট করে ওইটা পয়সা ক্রিমিনাল অ্যাক্টিভিটি থেকে আসছে, তারা পয়সা ওইটা সিজ করতে পারত। Proceeds of Crime Act makes it possible for a senior enforcement officer and HM Revenue and Customs officer, police officer, serious fraud office officer or accredited financial investigator to apply to a magistrate's court for an account freezing order. এখন Proceeds of Crime Act মানে এখানে আপনার এটার মাধ্যমে এটা পসিবল হয় এখন যে ম্যাজিস্ট্রেটস কোর্টের মধ্যে অ্যাকাউন্ট ফ্রিজিং অর্ডারের জন্য আপনার ব্যাংক অ্যাকাউন্ট, বিল্ডিং সোসাইটি অ্যাকাউন্ট ফ্রিজ করার জন্য তারা এখন অ্যাপ্লিকেশন করতে পারে। সেটা HM রেভিনিউ অ্যান্ড কাস্টম অফিসার, পুলিশ অফিসার বা ফ্রড ইনভেস্টিগেশন অফিসাররা করতে পারে। দ্য অফিসার ক্যান ডু দিস ইফ he or she has reasonable grounds to suspect that monies held in an account are either recoverable property or as property obtained through unlawful conduct or intended by a person or used in unlawful conduct, for use in unlawful conduct. In either পয়সাটা আসছে একটা ক্রিমিনাল অ্যাক্টিভিটি থেকে যেটা রিকভারেবল, or intended by any person for use in unlawful conduct, যে এটা এই পয়সাটাকে একটা ক্রিমিনাল বা আনলফুল কন্ডাক্টের মধ্যে এই পয়সাটাকে ইউজ করা হবে, ওইটাই যদি তারা সাসপেক্ট করে রিজনেবল গ্রাউন্ড থাকে তখন তারা অ্যাকাউন্ট ফ্রিজিং অর্ডার অ্যাপ্লিকেশন কোর্টে করতে পারে। The minimum balance in the account is 1000 and the application will usually be made উইদাউট নোটিস। যে এখন কিন্তু অ্যাকাউন্ট ফ্রিজিং আপনার ব্যাংকে পয়সা আছে, তারা যদি সাসপেক্ট করে ওই পয়সাটা আসছে ক্রিমিনাল অ্যাক্টিভিটি থেকে, ওই পয়সাটাকে ইউজ করা হবে একটা ক্রিমিনাল অ্যাকশানে, ইন্টেন্ডেড টু ইউজ ফর ক্রিমিনাল অ্যাকশান, তখন তারা এখন অ্যাকাউন্ট ফ্রিজিং অর্ডারের জন্য অ্যাপ্লিকেশন করতে পারে এবং সেটা উইদাউট নোটিস তারা এটা অ্যাপ্লিকেশন করবে। কোনো নোটিস কিন্তু আপনাকে দিবে না, কিন্তু আপনাকে ওইটা অ্যাপ্লিকেশন করার পরে তখন আপনাকে জানানো হবে যে এই অ্যাপ্লিকেশনটা করা হয়েছে। যে কিভাবে করে ওই অ্যাপ্লিকেশনটা অ্যাকাউন্ট ফ্রিজিংয়ের অর্ডারের জন্য সেটা আমি নেক্সট সেগমেন্টে বলবো, কিন্তু তারা অ্যাপ্লিকেশন এখন করতে পারে, করার আগে তারা বলবে না, করার পরে তখন তারা বলতে পারে। I will pass to my colleague Barrister Faisal Saifi to go on more on fraud and money laundering, please. Yeah.
Thank you. Section 1(1) of the Fraud Act 2006 defines fraud for the purposes of the criminal law. The offence is triable either way. That means it's triable both in the Crown Court and in a magistrate's court. If it is tried in a Crown Court, or if somebody is convicted in a magistrate's court and sentenced in a Crown Court, that person can receive up to 10 years in prison for that conduct. The offence under Section 1 can be committed in one of three ways. Those three ways are set out in the succeeding provisions of the Fraud Act 2006, Sections 2, 3 and 4. In Section 2, that sets out fraud by false representation. That is when someone actively says something that is untrue. Section 3 is fraud by failing to disclose information. So that covers the situation when someone remains silent, although they might have an obligation to disclose a fact, or they consciously mislead someone by not stating the full facts. Thirdly, fraud can be committed by an abuse of position, and that is, for example, in the situation of a bank and its customer, or a solicitor, or somebody else in a position of trust who then abuses that trust. The drafting of the Fraud Act 2006 makes it clear that there is only one offence of fraud, although it can be committed in these different ways. The two elements of the offence of fraud are firstly dishonesty, and secondly an intent to make a gain, cause a loss to another, or to expose another to a risk of loss. Dishonesty, being the first element, is not actually defined in the Fraud Act 2006. That is defined elsewhere in the common law. And gain and loss are defined in the Fraud Act, and they are defined in Section 5. Dishonesty, firstly, is the starting point for any discussion of fraud. Lord Justice Millett, a very highly esteemed judge who went on to become a Lord of Appeal in the Ordinary, has famously stated that in all our jurisprudence there is no sharper distinction than that between fraud and dishonesty cases and those of negligence and incompetence. What his lordship meant was that negligence and incompetence, carelessness, are all on one side, whilst fraud and dishonesty are a thing apart. It is not sufficient to prove carelessness or negligence. One really has to go far beyond that to prove dishonesty. It's also important in this context to understand the difference between dishonesty and motive. They're entirely separate matters. So again, by way of an example, somebody might forge a signature in order to obtain a payment to themselves of money which they believe they are entitled to. Although they might well be entitled to that money, the forging of the signature itself is dishonest, even if the motive to obtain money which belongs to that person is a good one. In short, as Lord Nichols has also observed, for the most part, dishonesty is to be equated with conscious impropriety. The definition of dishonesty was defined in a case called Ivy and Genting that reached the Supreme Court. That was an unusual case and one with an interesting factual background. The claimant was a professional gambler. He played the card game of Punto Banco Baccarat at the defendant's casino and went on to win £7.7 million. He did that by using a technique called edge sorting, where he would exploit the marginal differences in the patterns on the backs of cards. He would ask the croupier to rotate those cards of high value, turn them upside down before those cards were dealt and bets placed on them. The croupier and the casino didn't know what was going on, but when they found out, they refused to pay out the gambler's winnings. In proceedings in court, it was found that the gambler had been dishonest, and the court went on to define what dishonesty meant. Lord Justice Thomas, giving the judgment of the Supreme Court, aligned the definition of dishonesty across the civil and criminal law. His lordship stated, when dishonesty is in question, the fact-finding tribunal must first ascertain subjectively the actual state of the individual's knowledge or belief as to the facts. The reasonableness or otherwise of his belief is a matter of evidence, often in practice conclusive, going to whether or not he actually held that belief. But it is not an additional requirement that the person held a reasonable belief. The question is whether it was in fact genuinely held. When once his actual state of mind is established, the question is whether his conduct was honest or dishonest is to be determined by the fact finder, normally a jury in criminal cases, by applying the objective standards of ordinary, honest, decent people. There is no requirement that the defendant must appreciate what he did was dishonest. There used to be what was regarded as the third limb of the gauche test that required a defendant to have himself appreciated what he was doing would be regarded as dishonest by ordinary decent people, but that has now been got rid of, and an effort has been made to simplify the test of dishonesty. Nonetheless, both the subjective and the objective limbs of the test of dishonesty set high hurdles. The objective test is essentially a jury question, namely consideration of how an honest, decent person would have acted in the circumstances. He or she does not need to have acted as a reasonable person would have done, merely as an honest person would have done. That normally means that he should not tell lies or knowingly mislead others without a very good explanation. The more problematic aspect of the test of dishonesty is the subjective limb, and that is the point on which I now wish to talk. Knowledge is the key underlying aspect of the subjective element. In a case called Barden and Society Generale, Mr. Justice Peter Gibson outlined 5 states of knowledge. There is firstly actual knowledge, there is secondly willful blindness, and below that there are different standards of what are described as constructive knowledge or notice. That those are situations where the person doesn't actually know the actual state of affairs, but a reasonable person in his shoes might well have appreciated what was actually going on. Type 1, actual knowledge, is the most difficult to prove and requires the clearest evidence to do so. Type 2, blind eye knowledge, may be imputed to a person if he turns a blind eye, as Nelson is supposed to have done at Copenhagen when he put a telescope up to his blind eye so as to avoid seeing a signal for him to call off his attack. In legal parlance, what this means is that a person deliberately abstains from making an inquiry so as to avoid obtaining certain knowledge of something he already suspects to be the case. Anything short of actual knowledge or blind eye knowledge is generally regarded as a negligence standard. Traditionally, the requirement in fraud cases has been to require consciousness that one is transgressing ordinary standards of behaviour, or blind eye knowledge based on clear suspicions that the defendant consciously ignored. The negligent failure to ascertain the true state of affairs has generally been regarded as inadequate. As to the content of the knowledge that a defendant should hold in order to be found liable, whether as a principal or as an assistant, the defendant needs to have knowledge or belief of the particular wrongdoing in question. It has not been settled whether knowledge of some collateral or other wrongdoing might be sufficient for a defendant to become liable for fraud. In linked civil cases, courts have variously emphasised the need for knowledge of the critical facts. This has been described on different occasions as consciousness of those elements of the transaction which make participation transgress ordinary standards of behaviour. Let a defendant know in broad terms what the design is, or that the defendant must know each relevant fact. A defendant is not entitled, however, to make the disreputable argument that he did not know he was stealing from the claimant because he thought he was stealing from someone else. In those circumstances, it may be sufficient for a defendant to have known that he was involved in a money laundering operation, although he did not know of the original fraud itself. Where the gravamen of the allegation is the wrongful diversion of money belonging to another, as it very often is in fraud and money laundering cases, it is certainly sufficient to have actual or blind eye knowledge that the money was not at the free disposal of the principal. It is not necessary for the defendant to know all of the details or the precise legal position, but dishonesty in a general sense is not regarded as sufficient. Thank you.
Thank you, Faisal. দর্শক আপনারা শুনছেন ব্যারিস্টার ফয়সাল সাইফি, দীর্ঘ প্রায় 15 years, more than 15 years experienced criminal lawyer, specialist barrister, ফ্রডের উপর বলছিলেন কিভাবে ফ্রড আপনার হতে পারে, কি ধরনের নলেজ আপনার থাকতে হবে, যে একটা ক্রিমিনাল অ্যাকশনের জন্য ইন্টেনশন থাকতে হবে, ওগুলোর উপর উনি আপনার এক্সপ্লেইন করতেছিলেন যে লিগ্যাল রুলগুলা, গাইডেন্স কি আছে, আপনার কোর্ট অফ অ্যাপিলের যে গাইডলাইনগুলো দিয়েছে ওগুলো উনি এক্সপ্লেইন করতেছিলেন। আমরা শর্ট একটা ব্রেকে যাচ্ছি, ব্রেকের পরে আমরা আবার ফিরে আসব। আমি সলিসিটর শাফিউল আজম, প্রিন্সিপাল অফ আজাম অ্যান্ড কো সলিসিটার্স, এবং আমার সাথে আছেন আমার কলিগ ব্যারিস্টার ফয়সাল সাইফি। সবাই আমাদের সাথে থাকুন।